a part of the offense definition. Russia also ignores the Montreal Convention's stated object and purpose of deterring unlawful acts against the safety of civil aviation. Note the focus on unlawful acts, not intentional acts, as this case painfully illustrates those who unlawfully target aircraft of any kind cannot be trusted to keep civil aviation safe. But, Madam President, members of the court, even if intent to destroy a civilian aircraft were required, the destruction of flight MH17 was still intentional. Firing a weapon that is incapable of distinguishing military from civilian targets into civilian trafficked airspace establishes intent to destroy a civilian target. The capabilities and practical operation of the Buk system are explained in the testimony of Dr. Anatoly Skorik, a colonel and professor at Kharkiv Air Force University. I'd like to acknowledge that Dr. Skorik has taken time from his important responsibilities in Ukraine to be here today. Dr. Skorik explains that Buk operations are normally carried out under the direction of a combat control center. A single TLAR can operate autonomously, but with severe limitations. In autonomous mode, a commander must make firing decisions on the basis of the TLAR's sparse indicator screens and friend or foe system. This system, however, only identifies allied military aircraft as friends. Everyone else, military or civilian, is marked as a foe. The aiming screen provides information about a target's location and general parameters, but not enough information to tell a civilian plane from a military plane. Dr. Skorik therefore concludes, quote, "The technical capabilities of the Buk M1 TLAR in autonomous mode do not make it possible to distinguish a civilian aircraft from a military one, and this situation is further exacerbated under highly stressful conditions experienced by the combat crew," end quote. Dr. Skorik's conclusion is shared by the government of the Netherlands. Quote, "The Buk system was not capable of distinguishing between enemy military aircraft and civilian aircraft," end quote. Only in its rejoinder does Russia respond with an opinion by Lieutenant Colonel Yuri Bezborodko. Ukraine objects to the admissibility of this untimely submission. More importantly, Bezborodko concedes every key point. Begin with the TLAR's aiming system. Bezborodko admits that this system classifies a target as ballistic, helicopter, or aerodynamic. It does not distinguish types of airplanes. He then admits that, quote, "In practice, it is rarely possible to unambiguously determine the type of airborne target based solely on the performance of this system," end quote. That is consistent with Dr. Skorik's testimony. A Dutch police report, which Russia embraces and submitted in its rejoinder, further explains why the available radar signals are insufficient to distinguish military from civilian aircraft. The size of a blip on the screen may vary for different kinds of aircraft, but that is only helpful information when multiple blips are in view. And in order to avoid detection, quote, "An autonomous TLAR will limit its radar image. This diminishes its capacity to identify a target," end quote. The Joint Investigation Team agrees. Bezborodko also points to the TLAR's camera, but he makes a critical concession. Quote, "Adverse weather conditions, cloud cover, and a distance to the target can make identification difficult," end quote. Difficult is an understatement. As the Dutch police explain, quote, "If a target is flying above the clouds, it is out of reach of the camera. This limitation is foreseeable by the TLAR's crew," end quote. The Joint Investigation Team notes that this was the case at the relevant time. Quote, "On a cloudy day, like the afternoon of 17 July 2014, the TLAR's camera cannot be used," end quote. Finally, Bezbarocco admits that, quote, difficult ground situation, time pressures, and a certain extreme situation have an impact on the process of combat work, end quote. This again is consistent with Dr. Skorik's explanation that a Buk Tilar in autonomous mode must make firing decisions in a matter of seconds. To summarize, every material fact is undisputed. Ukraine's expert, Russia's expert, the Dutch police, and the JIT agree that the friend or foe system cannot distinguish a civilian aircraft. All agree that in practice, the crew cannot use the available targeting information to determine aircraft status. All agree that in autonomous mode, the TLAR's radar field is narrow, limiting its ability to compare multiple objects. All agree that the camera cannot see a plane flying above clouds. And all agree that the crew must make lightning-quick decisions. Ultimately, Bezbarocco only disagrees with Dr. Skorik's choice of words. Dr. Skorik concludes from all of this that the Buk Tilar in autonomous mode lacks a practical ability to distinguish civilian from military aircraft. Bezbarocco concludes that civilians being hit is, quote, inevitable, end quote. These are two ways of saying the same thing. Once this factual point is settled, the legal analysis is straightforward. On any interpretation of Article 11B, intent is established by proof that the perpetrator fired at civilian traffic skies with a weapon that could not distinguish civilian from military aircraft. The word intentionally has an ordinary legal meaning. There are degrees of intent, and a purpose of causing a specific consequence is just one of those degrees. For example, Professor Ben Saul explains that an attack targeting a military installation, but with knowledge that civilian aircraft are there and will be destroyed, constitutes intentionally destroying an aircraft under the Montreal Convention. Russia's own criminal code reflects that, quote, an act committed with direct or indirect intent shall be recognized as a crime committed intentionally, end quote. This includes where, quote, the person realized the social danger of his or her actions, end quote. This, at a minimum, describes the intent of a person who endangers civilians by firing a weapon he knows cannot distinguish military from civilian aircraft. Russia invites this court to consider intent in light of IHL, but doing so would only confirm Ukraine's conclusion. As this court explained in its nuclear weapons advisory opinion, quote, states must never make civilians the object of attack and must consequently never use weapons that are incapable of distinguishing between civilian and military targets, end quote. The ICTY, applying this principle, confirms that the question is not whether the weapon is indiscriminate in some abstract sense, but in the circumstances in which it is used. It therefore does not matter whether there could be some theoretical set of circumstances, no time pressure, no clouds, a wide radar screen with plentiful blips to compare, where a Buk Tilar commander might be able to identify a civilian aircraft. Under the real-world circumstances faced by the DPR members who fired the missile, the Buk Tilar could not distinguish civilian from military targets. Using that weapon in those circumstances constitutes making civilians the object of attack. In other words, using that weapon in those circumstances constitutes intentionally destroying a civilian aircraft. Madam President, members of the court, since the DPR's destruction of Flight MH17 violated the Montreal Convention, it was an act which may not be funded under Article 2(1)A of the ICSFT. There is no serious dispute that Russian officials, including members of the 53rd Anti-Aircraft Brigade, provided the Buk Tilar that was used to commit this act. On this point, the Dutch police and the independent investigator Elliot Higgins submitted detailed statements specifically for this case. Russia ignores them. The book was provided knowing it was to be used to commit a terrorist act. As Professor Tuvnan established, providing a weapon to a group notorious for committing acts covered by the Convention establishes the required knowledge. A United States court reached the same conclusion in a case specifically about Flight MH17, and specifically brought under legislation implementing the ICSFT. The court held that if the victims' families can prove that the DPR carried out attacks on civilians, and that these attacks were widely reported, that would establish that the DPR's funders knowingly financed terrorism. That is exactly what Ukraine has proved in this case. By the summer of 2014, UN monitors and others extensively documented the DPR's pattern of committing terrorist acts. The brutality of Igor Girkin, the specific DPR leader who requested the book from his Russian benefactors, was particularly infamous. But here, knowledge can be established with even more granularity. Members of a Russian air defense brigade surely knew the limitations of the system they were providing. They knew the implications of providing a Buktilar alone. They knew the skies were open to civilian traffic. And they knew that the DPR would have no practical ability to distinguish military from civilian targets. In short, they knew that striking civilian aircraft was, in the words of Russia's own expert, inevitable. Russian officials provided the Buktilar in the knowledge that it was to be used to achieve this inevitable result. So they knew that the book was to be used to commit a Montreal Convention offense, making these officials guilty of terrorism financing under Article 2.1 of the ICSFT. The destruction of Flight MH17 is another tragic example of the consequences of Russia's total non-cooperation. Under Article 18 of the ICSFT, Russia had an obligation to take practicable measures to prevent terrorism financing. It would have been practicable for Russia to instruct its officials not to supply the DPR with weapons, and at the very least, not to supply a partial system unable to distinguish civilian from military targets. But Russia did nothing of the sort. Russia also could have policed the border. On the 24th of May 2014, the State Border Guard of Ukraine sent one of many requests to the Russian border guard. Ukraine urged, in the interest of safeguarding civilians specifically, that Russia urgently implement measures to stop the smuggling of weapons across the border. Russia ignored that plea. It did not even respond until months after the destruction of Flight MH17. And then, the Russian border guard deflected responsibility, making a bizarre claim that it had no authority to address, quote, the passage of vehicles transporting cargo, end quote. That is, Russia's border guard disclaimed authority to guard Russia's border. Had Russia answered Ukraine's call to cooperate in good faith, no Buktilar could have entered Ukraine on the 16th of July, 2014. In legal terms, this practicable measure could have prevented an Article 2 offense. In human terms, 298 people would still be alive. The 3 infants on board would be 9 years old today. These were preventable deaths. Russia could have prevented them. After those deaths, Ukraine confronted Russia with allegations that the supply of the Buk constituted an Article 2 offense. Article 9 of the ICSFT required Russia to investigate that allegation in good faith. Article 10 required Russia to prosecute or extradite the perpetrators. Instead, Russia obstructed multilateral efforts to investigate and prosecute those responsible. Most brazenly, this past February, President Putin bestowed on the 53rd Anti-Aircraft Brigade the honorary title of Guards for their, quote, mass heroism and valor, end quote. That is how Russia responds when its own officials finance terrorism and cause mass civilian destruction. Not cooperation, not prevention, not investigation, not punishment. Instead, high honors. That is not the act of a state that takes its obligations under the Convention seriously. Madam President, members of the Court, the ICSFT also makes it an offense to finance acts covered by the Bombings Convention. Ukraine's largest cities, hundreds of kilometers from any fighting, faced a campaign of such terrorist bombings. These bombings targeted a member of parliament in Kyiv and the leader of an NGO in Odessa. Kharkiv, Ukraine's second largest city, was hit the hardest. One resident described the atmosphere in the city this way, quote, "The anxiety raised by the bombings is painful. That's the whole point of terrorist acts, to bring people to a pitch of fear where they can be easily broken," end quote. The bombs and money to conduct this campaign came from Russian persons. Yet once again, Russia did nothing to prevent this financing and nothing to investigate it or suppress it. Time does not permit me to address every part of this bombing campaign and the way it was financed. Nor is that necessary. Russia disputed almost nothing about this subject in its counter-memorial. As with Flight MH17, Russia improperly makes new arguments in its rejoinder. For example, in its counter-memorial, Russia did not dispute the supply of MROA rocket launchers, which are possessed only by the Russian military. Nor did it dispute the fact that terrorists used this Russian weapon to attack the regional headquarters of a major bank. Only in its rejoinder did Russia offer a purported expert to try to explain away these inconvenient facts. This untimely expert opinion, another one, should not be admitted. But even that is an exception. Mostly, Russia just ignores the evidence. I will therefore focus on two serious bombings in Kharkiv and the nearly undisputed evidence that they were financed by Russian persons. When the Court revisits the written pleadings, it will see similar patterns in other incidents and a similar failure by Russia to meaningfully engage. The Stina Rock Pub is a nightclub in downtown Kharkiv that was popular among supporters of Ukrainian unity. On the evening of Sunday, 9 November 2014, an SBM limpet mine exploded inside. OSCE monitors visited the scene, reporting that, quote, "The explosion resulted in a number of injured people," end quote. In its counter-memorial, Russia did not dispute that this was an offense under the Bombings Convention. Only in its rejoinder did Russia contest that point. But the Stina attack fits squarely within the Bombings Convention. Stina Rock Pub was a place of public use. And detonating a military-grade mine inside of a crowded bar undeniably reflects an intent to cause death or serious bodily injury. In paragraph 476 of its rejoinder, Russia now calls the Stina Pub a, quote, "military target," end quote, and claims that it falls under the military exclusion clause in Article 19. The Court should pause here. Russia is saying that a crowded nightclub is a legitimate target. The callousness of that argument speaks volumes. It also has no basis in fact or law. Russia's explanation is that members of a Ukrainian battalion who had returned from fighting in Donbass were at the nightclub. Russia bases this argument on rumors printed in a pro-Russian blog, which itself admits it is, quote, "impossible to confirm this fact," end quote. Russia also does not identify what armed force, as that term is defined in IHL, it believes carried out this attack. The bombing thus cannot be an activity of armed forces during an armed conflict that is excluded under Article 19. While the Court may stop there, the attack is separately covered by Article 21b of the ICSFT. Even in its rejoinder, Russia does not address that point. I will just add two brief observations. First, the ICSFT has no armed forces exclusion akin to Article 19 of the Bombings Convention, so Russia's exclusion defense is irrelevant. Second, Article 2.1b covers acts intended to harm civilians and any other person not taking an active part in the hostilities in a situation of armed conflict. As the U.S. State Department explained, this language was specifically adopted, quote, to ensure that the convention encompassed the financing of attacks on off-duty military personnel, end quote. Even assuming some off-duty servicemen happen to be at the nightclub, this is precisely the type of attack Article 2.1b was meant to cover. Madam President, the Russian persons who delivered limpet mines to Kharkiv committed a terrorism financing offense under Article 2.1. Russia does not dispute that the limpet mine was provided with knowledge it was to be used to commit a terrorist act. There's no innocent explanation for delivering a bomb to a peaceful city. Russia instead denies that Russian persons supplied the mine. The evidence says otherwise. An SBM limpet mine is typically used in naval warfare. We're not talking about an improvised bomb someone could build at home. Only militaries have it. And Russia offers no evidence this was a Ukrainian military mine. Major General Ivan Gavriluk of the Ukrainian Armed Forces testified, without dispute, that Ukraine had no limpet mines in Donetsk and Luhansk oblasts. Less than 2 weeks after the Stina attack, Ukrainian law enforcement discovered in the Kharkiv region another SBM limpet mine, marked with the number 90. Russia ignores this evidence. As General Gavriluk testified, this marking reflects a 1990 production date, and quote, the UAF has not had any limpet mines manufactured after 1987 in its service, end quote. Russia ignores that too. This mine could only have come from Russian sources. In other words, undisputed evidence shows that Russian persons delivered limpet mines to Kharkiv. That is more than enough to establish a financing offense. But there is even more evidence tying the perpetrator, Marina Kovtun, to Russian persons. That evidence includes Kovtun's own testimony, which Russia focuses on and calls unreliable. Yet there is also hard evidence, which you can find at tabs 39 through 42 of your folder, corroborating what she said. Border crossing records, intercepted conversations, seized assault rifles, which were registered with Ukrainian military units in Crimea until the occupation. More fundamentally, the court should view the record as a whole. Russia has not disputed that Russian persons delivered an overwhelming amount of weapons into Ukraine in 2014 and 2015. During the same period, a Russian-made, military-grade mine exploded at a nightclub popular with supporters of the Revolution of Dignity. It defies credulity to think this attack was financed by anyone other than Russian persons. Russia offers even less of a defense of the deadly bombing of a Kharkiv peace rally. On the 22nd of February 2015, Ukraine commemorated 1 year since the revolution. The people of Kharkiv gathered to rally for peace and unity. They were greeted by a MH17 anti-personnel mine. This terrorist attack killed 3 civilians and injured many more. Like a limpet mine, the MH17 is a Russian military weapon. The 100 in its name means it has an intended lethal range of 100 meters. Russia does not dispute that the rally bombing was an offense under the Bombings Convention, and also an act covered by Article 2.1b. Russia also cannot deny that anyone who delivered an anti-personnel mine to Kharkiv knew it was to be used to commit a terrorist act. Russia's only cursory defense is to say there is, quote, no evidence, unquote, that the mine came from Russia. Russia is again ignoring the record. The relevant evidence was summarized by a Ukrainian court judgment in your folder at tab 45. It includes a recorded conversation of the perpetrator speaking with other inmates. The evidence also includes a perpetrator's emails, quote, with officers of the Russian Special Services, end quote. Russia engages with none of this. But as with the Stina Rock pub bombing, there is a more fundamental point. Anti-personnel mines are not readily available. Undisputed evidence shows an influx of Russian weapons during this time period into Ukraine in general, and Kharkiv in particular. The only reasonable conclusion is that when terrorists use a Russian-made, military-grade mine against patriotic Ukrainian civilians rallying for national unity, that mine came from Russia. As I noted at the outset, these two bombings are just illustrative examples. Kharkiv faced a rash of bombings, a similar pattern repeated across the country. It would have been practicable for Russia to prevent the supply of its own military's mines into Ukraine. But Russia took no practicable measures to prevent this terrorism financing, nor is there any evidence that Russia did anything to investigate or suppress this terrorism financing. Instead, Russia chooses to defend the legitimacy of bombing nightclubs. Madam President, members of the court, the evidence is unequivocal. Russia violated the ICSFT in connection with the financing of attacks on civil aviation and terrorist bombings. I now ask, Madam President, that you call upon Ms. Marny-Cheek.
I thank Mr. Zients, and I now invite Ms. Marny-Cheek to address the court. You have the floor, Madam.
Madam President, members of the court, it is a pleasure to appear before you today on behalf of Ukraine. As Professor Tuvenon established earlier today, it was well known that in 2014, the DPR and LPR were attacking civilians as part of a campaign of intimidation and terror. Yet funds continued to flow across the border from Russian persons into the hands of those committing these terrorist acts. Ukraine repeatedly sought assistance from Russia to prevent this financing, raising grave concerns about the money and weapons flowing from Russia's territory. But instead of cooperation, instead of taking measures to prevent and counter preparations for the commission of terrorism financing offenses, Russia did not engage in any meaningful way. As Ukraine's requests for cooperation were met with silence, funds continued to flow to DPR, LPR, and other groups engaged in terrorist acts. Mr. Zients has already spoken of the knowing funding of terrorist acts under Article 21A. I will speak of the knowing funding of terrorist acts covered by Article 21B, specifically shellings that targeted civilians. After speaking in some detail of these terrorist acts and the supply of weapons used to commit them, I will then return to Russia's utter disregard for its obligations under the ICSFT to prevent and counter preparations for terrorism financing, as well as Russia's failure to cooperate in the investigation and suppression of terrorism financing. In the span of 30 days, in January and February 2015, shells rained down on civilians in major Ukrainian cities far from the contact line, coinciding with an intense period of diplomacy and negotiations, which ultimately led to the Minsk II agreement. Each of these attacks involved multiple launch rocket systems from Russia. Each attack was widely publicized. And after each of these attacks, Russian officials continued to supply DPR fighters with more of these weapons. BM-21 Grads were supplied to DPR in early January. Days later, BM-21 Grads were used to shell a civilian checkpoint at Volnovakha. After Volnovakha, more BM-21s were sent to the DPR fighters. 11 days after Volnovakha, a neighborhood in Mariupol was shelled. Then yet another MLRS was provided to the DPR, this time a BM-30 Smerch. And 17 days after Mariupol, civilians were shelled in Kramatorsk. By supplying weapons in these circumstances, Russian persons committed terrorism financing offenses within the meaning of Article 2 of the Convention. The first in these series of attacks was the shelling of a civilian crossing and vehicle inspection point near Volnovakha, the Buhas checkpoint. At 14:25 on a Tuesday afternoon, the 13th of January 2015, at least 88 rockets rained down on a line of civilian vehicles, hitting a bus full of pensioners. 12 passengers were killed and 19 were injured. In the months leading up to the attack, vast amounts of monetary support and Russian weapons flowed to the DPR and other illegal armed groups in eastern Ukraine. This large-scale effort, both overt and covert, raised millions of rubles and provided weapon systems and other military equipment to the same groups publicly named by the OHCHR as engaging in a campaign of intimidation and terror against Ukrainian civilians. It is undisputed that in the weeks prior to the Volnovakha attack, Russian officials supplied illegal armed groups with BM-21 Grads, the weapon used in the attack in Volnovakha. The supply of these weapons was done with the knowledge that they would be used to carry out a terrorist act under Article 2.1 of the ICSFT. Russian officials knew to whom they were supplying these destructive weapons. The DPR and other illegal armed groups had a well-documented track record of targeting civilians. Knowingly providing such a group BM-21 Grads is an offense under Article 2.1. Once the weapons were provided, the Article 2 offense was complete. I respectfully remind the Court that Article 2 offenses are offenses regarding funding. Indeed, Article 2.3 confirms that a terrorist financing offense is complete, regardless of whether the funds are actually used in the end to carry out a terrorist act. That said, what happened after Russian officials provided the DPR with BM-21 Grads was, unfortunately, predictable. The weapons were used against a group of civilians lined up at a civilian vehicle inspection point 10 kilometers away from the contact line. As Professor Tuvanan established, an act whose certain consequence is civilian death is, quote, an act intended to cause death to a civilian under ICSFT Article 2.1b. It is undisputed that firing B-21 Grads at the Buhas civilian checkpoint was certain to have this result. It was well known that the checkpoint attracted long lines of civilian cars, especially in the afternoon. Satellite imagery captured on the morning of the attack shows a long line of civilian vehicles waiting to be screened. This image and other satellite imagery Ukraine presents to the Court today is available in the Judges folder at tabs 46 and 48 and is also in the record at Ukraine's reply Annex 2. The checkpoint facility itself was small. approximately 100 meters by 100 meters. General Brown, Ukraine's military expert, who is here as part of Ukrainian's delegation today, and whose expert reports are excerpted in the judge's folder at tab 47, has explained that at the distance DPR fighters fired the BM-21, rockets fall throughout a 1,300 by 700 meter area. This spread of fire guaranteed that civilians lined up at the inspection point would be harmed in the attack. This is sufficient to satisfy an act intended to cause death to a civilian under Article 21B. However, even under Russia's interpretation that the attacker must have intended civilian harm, the evidence demonstrates that the DPR intended to harm civilians. Satellite imagery confirms that Bujas was a civilian checkpoint designed to slow down cars and conduct vehicle inspections along a busy roadway. Its layout was consistent with U.S. peacekeeping guidance on a setup of police checkpoints. It was not a fortified military installation. Russia's attempt to compare the civilian inspection point to a DPR frontline combat position near Olenivka that was attacked by Ukrainian forces 15 months later only confirms how different these installations were. The undisputed testimony of Maxim Shevkoplas, the Ukrainian border guard official in charge of the Bujas checkpoint at the time, confirms that the facility performed administrative tasks such as inspecting vehicles and cargo. There were no Ukrainian armed forces units or equipment present. It did not play a role in the conflict. Russia also has responded with an academic debate about whether a civilian checkpoint qualifies as a military target under international humanitarian law because there were some small arms and minimal self-defense capabilities there. But the court need not engage in this exercise because whatever the civilian checkpoint status was, General Brown has explained that there was no plausible military explanation for DPR fighters to attack this civilian checkpoint. The only explanation that makes sense is an objective of harming civilians gathered at the checkpoint. Russia's arguments to the contrary are not supported by the evidence. Russia theorizes that the DPR may have been trying to neutralize the checkpoint for military reasons. But General Brown explains that if that was the case, the BM-21 Grad was the wrong weapon to use. Russian military doctrine, which the DPR presumably followed since they were using Russian weapons, prescribes that the minimum target size for a BM-21 is 400 meters by 400 meters. The Bujas checkpoint was 4 times smaller than the minimum target. Russia's military expert argues that it was not prohibited to use a BM-21 Grad in these circumstances. But that misses the point. As General Brown explains, artillery doctrine prescribes a minimum target size because if a target is too small, the rockets will likely miss and the target will not be destroyed. Indeed, this is precisely what happened at the Bujas checkpoint. None of the BM-21 rockets actually hit the checkpoint facility, but they did hit a civilian bus full of pensioners. As explained by General Brown, none of Russia's other arguments work either. If DPR fighters actually intended to destroy the checkpoint, they had access to more precise and effective weapons for the target. Russia calls attention to the presence of Kiev 2 battalion personnel at the checkpoint. But Kiev 2 was a police patrol unit that assisted the border guard with running the checkpoint. They did not have a combat role. Russia speculates that the attacks were part of a coordinated artillery campaign against locations deep behind the front line. But there is no evidence to support Russia's theory. Russia further suggests that the attack could have been a precursor to a ground offensive toward the checkpoint. Ukraine's satellite imagery experts confirmed there was no concentration of DPR fighters ready to follow the BM-21 Grad attack with a larger ground offensive. In sum, Russia's theories do not line up with reality, and they are not supported by the evidence. Attacking this small vehicle inspection post 10 kilometers behind the contact line with BM-21 Grads had no military purpose. Attacking a line of civilian cars with a weapon designed to blanket a large area with rocket fire made sense only for someone wishing to cause death and serious injury to civilians. Now, Ukraine does not have to prove both a purpose to intimidate a population and a purpose to compel a government to act under ICSFT Article 21B. But based on the nature and context of the act, both are present here. The only plausible explanation for the attack on the Buhas checkpoint was its value in intimidating the civilian population known to line up at that checkpoint. As already mentioned, the BM-21 is designed to be used where there is a large area of troops or vehicles gathered in the open. With no credible military purpose for this attack, the only conclusion is that it was another volley in DPR's reign of terror designed to intimidate civilians. Consistent with its name, Grad means hail in Russian. One BM-21 launcher fires 40 rockets in as little as 20 seconds. Being on the receiving end of such a hail of rockets, as General Brown has explained, quote, tends to cause fear, confusion, and panic. He goes on to say that it's, quote, highly frightening and creates a sense of helplessness for those subject to the attack. The timing of this incident is also telling. January through February 2015 was an intense period of diplomacy within the trilateral contact group that ultimately led to the Minsk II agreement. During this period, DPR and LPR were making demands for Ukraine to change its constitutional structure and pressuring Ukraine to make concessions. It is not a coincidence that a series of high-profile attacks against civilians happened during this short time frame, precisely when they would be most useful to compelling the government of Ukraine to act. The second shelling incident was in Mariupol. Just 11 days after the attack on the civilian checkpoint near Volnovakha, on the Buhas checkpoint, on the morning of Saturday, the 24th of January 2015, DPR deployed a barrage of no less than 154 BM-21 rockets against the Vostochny neighborhood of Mariupol, a densely populated residential area. 30 civilians died, including one child, and 118 people were injured. This second high-profile shelling of civilians with a Russian weapon damaged at least 53 residential buildings, 4 schools, 3 daycare centers, 8 grocery stores. Those Russian persons supplying the DPR with BM-21 Grads were well aware of the DPR's reign of intimidation and terror, its downing of flight MH17, the attack on a bus full of pensioners at a civilian checkpoint just days earlier. To be clear, within days of killing civilians in Volnovakha with BM-21 Grads, Russian officials supplied the DPR with more BM-21 grads. This act was plainly done with the knowledge of how such weapons would be used under Article 2.1 of the ICSFT. Accordingly, an Article 2 offense was completed once Russian officials delivered more BM-21 grads in the aftermath of Volnovakha. Per ICSFT Article 2.3, it does not matter what happened next. But regrettably, predictably, what happened next was the DPR used those Russian-supplied weapons against civilians again, this time in the residential neighborhood of Mariupol. The shelling of the Vostochny neighborhood was an act intended to cause death to a civilian under ICSFT Article 2.1b. Russia acknowledges there was no military reason to attack the Vostochny neighborhood. Instead, Russia claims that the DPR did not intentionally target the residential neighborhood, hypothesizing a variety of possible alternative targets, without committing to a single theory of which target the DPR fighters actually intended to attack. But once again, Russia's theories do not line up with the evidence. At times, Russia has suggested that Ukrainian National Guard checkpoint number 4014, a position on the edge of the city, was the real target. If so, it is undisputed that this small checkpoint could not have been targeted with 4 BM-21 grad systems without rockets also raining down throughout the residential neighborhood. General Brown explains that as with the Buhas checkpoint, BM-21 grads would not have been the right weapon system if that had been the target. Russia also suggests at times that the intended target might have been the Ukrainian National Guard company position number 4013, which was more than 2.5 kilometers away. But that explanation could not be credited with a series of firing errors so far-fetched that one would have to conclude that BM-21 grads were an indiscriminate weapon in the DPR fighters' incompetent hands. Once again, Russia has many theories, but none are supported by the facts. Russia speculates about potential technical malfunction, but when a BM-21 launcher malfunctions, its rockets fire erratically, impacting unpredictably in a scattered pattern. That was not the case here. Russia has offered no explanation for how the 4 separate BM-21 launchers used in the attack simultaneously malfunctioned in a way that produced a coherent impact pattern throughout the Vostochny neighborhood. With regard to the possibility of human error, Russia hypothesizes that maybe bad target coordinates were given. But the coordinates of the proposed targets, alternative targets, were also known to DPR, and DPR fighters are on record conducting pre-firing checks that would have caught any error in the coordinates. Russia suggests that the shelling was a precursor to a ground offensive toward the city. But as General Brown observes, there was no ground assault. Russia's military expert himself concedes, quote, "I do not see sufficient evidence of the actual attempt to capture Mariupol." Finally, intercepted DPR communications provide additional evidence that the residential area was intentionally targeted. The night before the attack, a DPR member told DPR fighters to hit Vostochny. The next morning, DPR fighters launched a massive strike on the Vostochny neighborhood. And the same DPR member who requested the attack the night before celebrated that it would make the people in Mariupol more afraid. While Russia points to additional intercepts that it claims shows some surprise about this attack on civilians, that does not negate this chilling evidence that some DPR members were rejoicing, and it is not surprising that other DPR members might not have known about the plan. The only plausible explanation is that the Vostochny neighborhood of Mariupol was intentionally targeted. As observed by the UN Undersecretary General 2 days after the attack, quote, "Mariupol lies outside the immediate conflict zone. The conclusion can thus be drawn that the entity that fired those rockets knowingly targeted a civilian population," end quote. Once again, while a terrorist act under ICSFT Article 21B need only be shown to have the purpose of intimidation or to compel a government to act, both are present here. The UN Undersecretary General described the Mariupol incident as an attack on a residential neighborhood. Such an attack is an act whose nature is to intimidate a population. And although direct evidence is not required, in this case it exists. Whatever Russia might speculate about others' reactions, there is simply no explanation for a DPR leader rejoicing that the residents of Vostochny will be more afraid. The shelling of Mariupol's civilian population occurred less than 2 weeks after the DPR killed the bus full of civilian pensioners at the Buhas checkpoint in Volnovakha, and just 1 week before a major diplomatic conference that would result in the Minsk II agreement. This was a period when political leverage was crucial, and the nature and context of events shows that the DPR saw these high-profile shelling attacks on civilians as providing leverage. Considering this political context, the shelling of the Vostochny neighborhood of Mariupol had the purpose of compelling the Ukrainian government to act. The final act I will discuss in early 2015 was the attack on the city of Kramatorsk. On 10 February 2015, DPR launched a series of BM-30 rockets, bombarding a residential area of the city. The attack, conducted at a Tuesday afternoon around lunchtime, damaged 15 residential buildings, as well as a kindergarten, an art school, a local hospital. 7 civilians were killed and 26 were seriously injured, including 5 children. Russian officials who supplied the DPR with a BM-30 Smerch, were well aware of the DPR's reign of intimidation and terror, its downing of Flight MH17, the attacks on Volnovakha and Mariupol. Russian officials knew that a barrage of rockets had killed a bus full of pensioners at a civilian checkpoint in Volnovakha, an act condemned by the UN Security Press Statement as reprehensible. Russian officials knew that less than 2 weeks earlier, an even larger barrage of rockets had landed on a residential neighborhood in Mariupol, an act the UN Undersecretary General observed knowingly targeted a civilian population. With this knowledge of how the weapon would be used under ICSFT Article 2.1, Russian officials provided the DPR fighters with a BM-30 Smerch. The BM-30 Smerch is a more sophisticated multiple-launch rocket system than the BM-21. Unlike the BM-21, where the rocket warhead explodes on impact, each BM-30 rocket contains 72 cluster munitions. These cluster munitions are released from the rocket as it flies over its intended target. After the cluster munitions are released, the rocket continues on its path and eventually falls to the ground. Supplying the DPR fighters with this advanced multiple-launch rocket system after they had used similar systems against civilians in Volnovakha and Mariupol completed an Article 2 offense. As already mentioned, under ICSFT Article 2.3, it does not matter what happened next. The funds were provided knowing that they were to be used in terrorist acts, whether those acts were ultimately carried out or not. But once again, predictably, the funds were in fact used against civilians, this time attacking the center of a residential neighborhood in Kramatorsk, more than 50 kilometers from the contact line. Using the BM-30 Smerch against the residential neighborhood in Kramatorsk was an act intended to cause death to a civilian under ICSFT Article 2.1b. As with the attack on the Vostochny neighborhood of Mariupol, Russia agrees there was no military reason to attack a residential neighborhood in Kramatorsk. Once again, Russia has various theories for what might have happened on that fateful day in February 2015. For example, Russia hypothesizes about various technical malfunctions and human errors that could have resulted in rockets overflying an airfield 5 kilometers away and hitting the residential area instead. General Brown has looked at those theories and found them unsupported by the evidence. After the attack on Kramatorsk, BM-30 debris and cluster munition impacts were identified across an area spanning more than 5 kilometers. As General Brown explains, he and Russia's expert agree that the cluster munitions from one salvo of BM-30 rockets cannot fall 5 kilometers from each other. In other words, if DPR had only targeted the airfield, cluster munitions would not have impacted in the residential area. This confirms that the airfield and the residential area were targeted separately. Russia's suggestion that human error, faulty rockets, or technical malfunction could have led to a 5-kilometer overflight are also highly unlikely. General Brown and Russia's expert agree it is very unlikely the operators of a BM-30 made so many errors while preparing and aiming the launcher that multiple rockets overshot their target by 5 kilometers. Further, as General Brown explains, faulty rockets typically burn out and fall short of their intended target. They do not overshoot. In the very unlikely event that some BM-30 rockets malfunctioned and overflew the airfield, the rockets' timing mechanisms would have still been programmed to release their cluster munitions over their intended target, supposedly the airfield. But instead, cluster munitions rained down on the residential area in Kramatorsk. The likelihood that multiple BM-30 rockets experienced a simultaneous overflight and timing mechanism malfunction is near zero. Russia's expert does not dispute that conclusion. Madam President, members of the court, at this stage, it's important to step back and consider Russia's explanation for these attacks together. According to Russia, a once-in-a-lifetime confluence of errors occurred in Kramatorsk, which could have led to cluster munitions falling anywhere, but instead, they landed in a residential area in a major city. This coincidence just so happened to take place 2 weeks after another implausible set of errors supposedly occurred in Mariupol, which resulted in more than 150 rockets landing in the center of a residential neighborhood. This also happened 1 month after DPR fighters targeted a civilian checkpoint, killing a bus full of pensioners in an attack that Russia has never been able to explain from a military perspective. Even if any one of these events could be explained in isolation, they cannot be explained in concert. Taken together, these were all acts intended to cause death or serious bodily injury to civilians far from the conflict zone. Targeting civilian areas of a major city far from the conflict zone has the purpose of intimidating a population under ICSFT Article 21B. For the attack on Kramatorsk, the political context is particularly clear, as the city was attacked just one day before Ukraine, Russia, France, and Germany were scheduled to meet at Minsk to negotiate a possible peace plan. The participants would have undoubtedly had this shelling and the other recent shellings in mind as they met to negotiate. The nature and context of the attack indicate that this was precisely the point. Following these three high-profile shelling attacks on civilians, the Minsk II agreement was signed in February 2015, and attacks on civilians subsided for a time. But the financing continued. Russian persons continued to supply funds to the DPR. Ukrainian civilians remained vulnerable to DPR's reign of intimidation and terror. In January and February 2017, that reign of intimidation and terror continued with the shelling of Avdiivka. Unlike Volnovakha, Mariupol, Kramatorsk, Avdiivka was quite close to the contact line, and many attacks in that city did target Ukrainian military personnel and equipment. But the DPR did not stop there. The DPR also carried out attacks against a northern residential area of the city where there was no evidence of a Ukrainian military presence. Russia has not provided an explanation for this beyond mere speculation, nor has Russia answered General Brown's conclusions on the inappropriate of using BM-21 grads in this populated area in Avdiivka, which were certain to harm civilians. In sum, despite the DPR's widely publicized history of attacking civilians, despite UN condemnations of these attacks, Russian persons continued to send the DPR a steady supply of weapons and other funds. Once a grad was used against civilians, more would come. In this court, Russia defends these acts of terrorism financing on a massive scale by putting forward post hoc, speculative theories for the DPR fighters' attacks. General Brown has considered and rejected those theories. More to the point, which should be considered regarding the knowing funding of terrorist acts covered under Article 21B is this question. What did those funders know at the time they were sending yet another shipment of weapons across the border to DPR fighters? Here is what those funders knew. They knew about DPR's reign of terror and intimidation. They knew about the shootdown of flight MH17. They knew about the DPR fighters' shellings targeting civilians, which were condemned by UN officials. And what did Russia do to prevent and suppress this financing of terrorism? Nothing. Russia took no practicable measures to stop this terrorism financing. It is to that topic that I will turn to next, but I would defer to Madam President as to whether this would be an appropriate time to break for lunch.
Thank you, Ms. Cheek. Your statement for the time being brings to an end this morning's session. The court will meet again this afternoon at 3 p.m. to hear the remainder of the first round of the oral argument of Ukraine. And as you've suggested, Ms. Cheek, when we resume this afternoon, we shall begin with the end of your statement. Thank you. The sitting is adjourned.